And we have two discussants, and I'm going to introduce the first one, Dr. Omri who will be followed by Dr. Lee. And Dr. Sender, you have the floor.
Thank you, Judge Infante, and many thanks also to the Korean Ministry of Foreign Affairs, to the International Tribunal for the Law of the Sea, to the Korean Society of International Law, and to all those who put together what has been a very interesting and enjoyable conference these past 2 days. Following the very rich and elaborate presentation we have just heard, and as per instructions, I will limit myself to very brief remarks concerning our topic today, UNCLOS as the nexus of marine protection norms. The term nexus can, of course, mean a central place for marine protection norms. It can also refer to a connection linking those norms together. Both meanings are very much appropriate in the present context. A first observation is that even if some might still argue that UNCLOS as a product of its time is not in its essence an environmental treaty, it is of course undoubtedly the case that the protection and preservation of the marine environment was and continues to be a significant part of the legal order spelled out by the Convention. It is further apparent that many of those marine protection norms, that is, the rights and obligations laid down in Part 12 of UNCLOS, are drafted in very wide terms that make them applicable to a potentially very large range of matters. Countering the increasing pollution by plastic and microplastics described by Director Oral, and the regulation of new energy generation activities discussed by Professor GAVOUNELI are just two examples of that. The fact that the well-being of the marine environment is a critical element of global environmental sustainability again makes UNCLOS both relevant and important in addressing contemporary concerns, including climate change. That UNCLOS may well play a part in addressing such global challenges to the benefit of all states was envisaged early on. Writing in 1992, Philip Allott paid specific attention in this regard to Article 192 of the Convention, which provides in rather simple terms that states have the obligation to protect and preserve the marine environment, nothing more. Allott depicted this provision as transmuting a banal legal relation into a universal social objective. And he added in rather poetic terms that the article is one of the most elegant and eloquent instances of the intersection of text and subtext in the Convention, the new wine of communitarianism spilling over from the old bottle of legal formalism. As Judge Kolodkin reminded us just yesterday, the application and interpretation of the Convention to meet new challenges must, of course, be done within the legitimate and permissible boundaries of legal technique. Dr. OLLINO has touched upon this point as well. These boundaries are, of course, a matter of appreciation in the particular circumstances, but they must nevertheless be kept in mind. UNCLOS is also a nexus of marine protection norms by pointing to specific avenues for the settlement of interstate disputes concerning these norms, and in particular, by establishing ICLOS as a central feature of the landscape. International legal experience has shown us all that there may be other possible means for the settlement of disputes related to the marine environment, and indeed other fora for such purposes. Some have gone on to say that a new international tribunal should be established to handle matters of serious international environmental harm without there being what they call jurisdictional uncertainty. I would point out that, fortunately, ICLOS is already there, and there is no doubt great value in drawing upon the particular expertise it has developed and indeed exhibited in this field. The Tribunal's impressive jurisprudence has endorsed the duty to cooperate, as well as the obligation to act with prudence and caution. This of itself shows that the Tribunal is already established as an important and highly relevant actor, not only for safeguarding the marine environment, but also for strengthening the very norms that seek to guarantee the protection of that environment. The Tribunal is indeed ideally suited to make sure that there is a broad and consistent view of all these norms and this of itself is a task of much significance. I will stop at that, and I thank you all for your kind attention.
Thank you very much, Dr. Sender. And now we'd like to invite Dr. Lee for the final comments and discussion, and then we go for a second round of comments among the panelists. Dr. Lee, you have the floor.
Yeah, thank you very much. I'm Beom Lee, and I'm teaching international law at Yonsei University Law School. Thank you very much for all the speakers' wonderful presentations. Before I speak, I have to express my thanks to Ministry of Foreign Affairs, Republic of Korea, and the Korean Society of International Law for the invitation. Today's presentations have dealt with the marine protection norms under or in connection with the 1982 United Nations Convention on the Law of the Sea very well. Actually, I have to make some comments regarding today's presentations, and then I'm very happy to get any comments responding to my comments. First of all, Professor GAVOUNELI's presentation was about, I think, just title New Forms of Energy, I see, but about exploring and exploiting new forms energy, I see, I think highly connected or under delimitation agreement. Professor GAVOUNELI especially pointed out the concept of a framework agreement between the two parties concerning cross-boundary resources, for example, petroleum, hydrocarbon cooperation. I think we have some examples of this kind of utilization agreement. Exactly speaking, framework delimitation agreement includes the content of utilization agreement. To understand this kind of utilization agreement for the exploration or exploitation of cross-boundary shared resources. First of all, we have to understand the unit area or reservoir, which means the area for joint exploration and or exploitation or transboundary reservoir. At this point, we also understand that utilization agreement has more than just a delimitation agreement which delimits maritime areas. However, this kind of utilization agreement has to include marine protection norms as well, because utilization entails the exploration or exploitation of shared resources. Actually, frankly speaking, old or just I call just the delimitation agreement old model or traditional model, a model of delimitation agreement just determined maritime areas belonging to a coastal state. But utilization agreement regarding the exploration or exploitation of cross-boundary shared resources is more developed delimitation model than old model. However, this kind of utilization agreement itself or in connection with the United Nations Convention on the Law of the Sea should include today's subject more contents concerning the protection of marine environment. For example, I'll show you one example. I show you. For example, the 2005 UK-Norway framework agreement regarding cross-boundary resources concluded in 2005 has few provisions regarding the protection of the marine environment. I'm not sure why the agreement has actually, I think, no provisions about the protection of the marine environment. I think the reason is that framework delimitation agreement is just focusing on the exploration or exploitation of shared resources. But not the protection of marine environment. And I'll move to Dr. OLLINO's presentation. I think I appreciate Dr. OLLINO's research on due diligence. Because, frankly, I like some flexible concepts. For example, due diligence obligation, or some, in maritime boundary delimitation, equitable solution. I like this kind of flexible concept. Dr. OLLINO's presentation was regarding due diligence obligations and marine environmental protection. I think the concept of due diligence is a very difficult concept in the sense of the application of the concept. She rightly indicated the vagueness of due diligence obligations, but I think this concept is oiling current marine protection norms. And the existence of due diligence obligations might be provided for the discretion to international courts and tribunals in a concrete case. And she also mentioned the issue of proceduralization of due diligence obligations. Several years ago, I read one book, and I found out the term proceduralization of due diligence obligations. But just generally, I agree. I agree with her argument. Just the relationship between proceduralization and interpretation. But I think proceduralization is, I think, highly connected with the participation of the affected people or entity to the decision-making process. So, for example, conducting the environmental impact assessment is also related to proceduralization. And if I recall one logic in the 2010 Parliament's case of the International Court of Justice, due diligence obligations are the obligation of conduct, or not result, already she mentioned. And due diligence obligations are highly related to the obligation of prevention. And I think she showed some darker side of, Paris, darker side of due diligence obligations, but I would like to point out a brighter side of the concept of due diligence obligations. First, the concept. Due diligence obligations, the concept is to guarantee the possibility of applying marine protection norms in international courts and tribunals. I mean discretion or margin of appreciation. And secondly, if the proceduralization of the due diligence obligations is entailed, the application of due diligence obligation would be more objective. I mean, for the process of proceduralization, I'm not sure that that expression is correct, but in the process of proceduralization, more and more factors should be taken into account. So, I mean, that means just the process of being objective. Yeah. And so I think due diligence obligation is a guiding or a key obligation for the protection of the marine environment. And lastly, Director Nilüfer's presentation. I don't have any comments about her presentation because I think she covers all the issues of plastic litter and the law of the sea. I agree with her view that plastics are threatening marine areas, and I think under the regime of the United Nations Convention on the Law of the Sea, I think we can regulate the issue because the plastic litter could be regarded as a pollution, and because Article 1 provides for the definition of pollution, so the plastics fall within the definition of pollution provided by the UNCLOS. Thank you very much. I finish my comments, and then as I said, I'm very happy to any response to my comments. Thank you very much.
Yes. Thank you very much to our discussants. Comments have been very enlightening and also provocative. And I would like to invite our panelists and discussants if they would like to supplement their presentations or to comment on other issues that were addressed by the other panelists. And I have one point I meant to provoke a little bit the discussion. It is the following question. Throughout the presentations, I have seen that the law of the sea is operating on different levels. We have the state level and we have the operators level, or those actors that are not really, or they're not equal with states, other private or public entities, but that are different sort of operators. How this general obligation to prevent, to preserve, the question that is how to transpose that obligation into specific standards and norms that are also obligatory upon those operators. I think Dr. Oral, Director Oral, Dr. OLLINO, and Maria, Dr. GAVOUNELI, and all the discussants refer to this. And the due diligence is to some extent a bridge or link between the obligations upon state and the obligations upon those operators who are really acting and conducting activities in the sea. But you are free to comment and to address the issues as you want. The order is not pre-decided, but whoever wants to speak, please request the floor.
I'll go.
Yes, of course, Dr. Oral.
All right, I'll be the first to take up the this opportunity, and very short because I know we're running out of time. I think in supplementing my presentation and perhaps also addressing the question you asked, I look at the Law of the Sea Convention, and it has been described as broad, flexible. It's really a remarkable convention. And we see it more so in that its application in different ways. But when we look at the obligations under it, I don't think we have to restrict it solely to the convention. And the point I was trying to make, and maybe didn't quite make it strong enough, but looking at other fora, such as the IMO, which is, of course, related to the Law of the Sea Convention, FAO, the UNEA, the Regional Seas Programs, and even others, perhaps, where the standards, the obligations, the standards, the actions, the measures that are required to be taken under the Convention, particularly under Part 12, are actually being implemented, are being activated. Now, does that meet the due diligence obligations? That's another issue, actually. It's a very interesting one. You know, what is the standard at which point the obligation has been fulfilled? And we know that the ICJ and the tribunals have actually given some guidance on that. So I would just like to conclude by saying that the theme, of course, of this conference is looking into future generations of the Law of the Sea Convention. And I think we can see that the Law of the Sea Convention, while it was negotiated during a set period of time under certain circumstances, is proven to be a very flexible and open convention that can, in many ways, address current challenges. And sometimes I think we have to look at it almost at the penumbra of the Law of the Sea Convention, that it can radiate beyond just its own text itself. So I would just stop there.
Thank you very much, Dr. Rodal. Someone else would like to address issues related to the topic of this panel or the core subject of the conference itself?
If I could add a few words here.
Please do.
Thank you so much. Let me react also to the comments of our discussants. There's no question that the Law of the Sea Convention is also an environmental convention, and indeed it is the environmental convention because we don't have any other global environmental convention. So to that extent, it's a precious tool, and it's also a precious commodity. And as Nilüfer suggested already, it is a very flexible tool because it incorporates elements from other areas as well. I would also argue, however, that apart from this horizontal amplitude, if you like, there is also a vertical element to the extent of regulation, to the norms included in the convention. Let's take the example of energy. What is it that we have in the Law of the Sea Convention? A basic obligation to protect and preserve the marine environment. That basic obligation is spelled out in the convention up to a certain extent, not entirely, especially if you think about procedural obligations. Environmental impact assessment, for instance, is absolutely minimal in the convention. It is then the work of international courts and tribunals to beef up, if you like, this type of obligations. ICLOS is doing that wonderfully well. I had occasion in the past to discuss the South China Sea arbitration, and with all the flaws of that particular award, the elements of beefing up environmental obligations were really almost exemplary. And then you go a level down, if you like. It's like a babushka, like a Russian doll, one element into the other. You go down a level and you go to the type of commercial agreements, that is actually the utilization agreements that you referred to, Professor Lee, earlier, where you don't really need to incorporate standards. Why? Because you refer to the common element of such standards that exist already and bind already the states involved. So a utilization agreement between the UK and Norway would not really need any procedural obligations, and especially environmental protection obligations, because there is a common element of obligations binding both states in advance. You may have a problem in the energy area when you are moving into new forms. For instance, we are very comfortable with oil and gas exploration and exploitation because we do know what kind of pollution it is that they would probably generate, and we know how to deal with that. But as we move into the offshore area with windmills and cables and whatnot, are we equally comfortable with the types of pollution that they may generate? They would not, we're not talking about oil that would have a direct, visible impact. We might actually be talking about magnetic fields generated by the cables or whatever. Do we know the impact of such kind of magnetic or electronic fields in the marine flora and fauna? Perhaps we need to beef it up a little bit. And therein, we might actually have recourse to private actors because there might be no regulation in international law. So we bring in the industry, if you like, and they would provide the elements of regulation. And then therein comes your discussion, Alice, because then you have to decide whether that is due diligent, whether that is enough for the states to rely on the industry, on private actors, or whether they actually need to educate themselves, because that's what they have to do at the end of the day, educate themselves and elevate this kind of private arrangements onto the normative level, thus beefing up the basic obligations already existing in the convention. As I said, one goes under the other in this type of babushka effect. I would stop there.
Thank you very much. Dr. OLLINO, would you like to say something about the due diligence as in the areas that have been discussed by your colleagues?
Yes, thank you. I will make two brief remarks. I would like to address what Professor Lee said about participation in decision-making process to, let's say, enlighten the content of due diligence. And I would only say, what are due diligence obligation if not a reflection of negotiating parties agreeing to not agree? So to some extent, they are postponing the conflict, which at certain point will come out just to a later stage. So in that sense, yes, participation in decision-making process also through the adoption of international standards would help increasing, let's say, agreements into what fulfill due diligence. And with regard to Judge Infante comments about non-state actors and other actors dealing with obligations, I am not sure that due diligence obligation can do so much when it comes to the responsibilities of non-state actors or parties other than states. Of course, they are often referred to as obligations that due diligence obligations are often referred to as obligations that requires vigilance on the part of the states towards non-state actors. But at the end of the day, you're always going to have, like activities which are outside the sphere of control of the state, thank God. And so, yeah, I would say that it would be best in that sense to conceive obligations of certain non-state actor instead of relying so much on due diligence obligation, which at the end of the day can do something up to a certain point. Thank you.
Thank you very much for these comments. Other comments from the discussions?
Thank you.
No?
Yeah.
Oh, yes. Dr. Sender, sorry. I've not seen you. Yes, very good. Take your time.
Very briefly, to answer your question, Judge Infante, on fulfilling the obligation under the convention by various domestic actors, it is, of course, necessary that that legal obligation be then translated into laws and then regulations and then orders and maybe eventually somebody shouting on a boat out at sea. But it is, of course, necessary to remember that this is not just in order to meet the legal obligation, but really to achieve the social purpose that that obligation and the convention that the law wants to achieve. So I think it's only if we're able to translate these legal obligations all the way down that we're able to really achieve the process of the convention in the first place. So that's important, bottoms up, just as much as it's important looking from the convention down. Thank you.
Thank you very much for your comments. Dr. Lee, would you like to say in 1 minute something or not?
Yeah, me? Yeah.
Yes, if you
Yeah.
want,
Yeah,
before
actually, yeah.
concluding.
Responding my comments, I was very happy with all the presenters' answers, and then actually, I have nothing to about anything new or new perspective, but I appreciate the region provided by Professor Gavouneli regarding the 2005 UK and Norway framework agreement. But just one thing is, before the conference started, I read just one provision, just regarding expressing environment standard, something blah blah. So, and so I just a little bit disappointed with few or no provisions about environmental measures or regulations included in 2005 UK Norway framework agreement. And then my intention was to introduce framework delimitation agreement or utilization agreement, because that a new model of delimitation agreement is providing for some possibilities or some margin to take some measures for the protection of a marine environment. So we can use that kind of ways to protect marine environment for getting new forms of energy. I see. Yeah, thank you very much.
Thank you very much. This is far more encouraging in the introduction of questions of delimitation, which goes beyond. It is within, but it goes beyond our core subject. But I would like to say that this panel has, at least to me, has fulfilled the expectations of the current challenges of the law of the sea and marine protection. And I would also like to thank the organizers of the conference for inviting us to discuss these issues. How important is to look at the transitions in the law of the sea towards new areas, new activities. The imagination is unlimited, and also the possibilities to get agreements, to have conflicts, but also to overcome them. Thank you very much for this possibility, for this chance. Thank you for your audience.
Thank you very much, Judge CAFFI, for moderating this session, and to also the speakers out here for wonderful speech and discussions. Thank you. This brings us to the end of session 5, as well as all the sessions that we prepared for this conference.